Black man, bald head. Hispanic man, curly hair. Brown skin, dreadlocks. These are just some descriptions of the hundreds of men I walk past every day. Many of them look just like Karen Reed. They were charged with murder. Police investigations were faulty. There was third-party culprit evidence. However, the state was hell-bent on convicting them. But because they lack a white woman's privilege, socio-political and socio-economic power, they do not look like Karen Reed. That is why they rarely attract the same media attention as her. If I was to ask you if Karen Reed has received due process of the law, I can only imagine what your answer would be. I want you to imagine what that same due process looks like for lower-class black and brown defendants. Bail is uncommon, there is racialized news coverage, and there is no federal oversight to sift out corruption. The purpose of a jury trial is not truly about truth. A fair trial is a constitutional right, but the legal system is a caste system designed to marginalize black and brown individuals. Therefore, exercising a right to a trial as a poor minority defendant comes with severe consequences. Alluding to Michelle Alexander's The New Jim Crow, author Chris Hedges points out, those who come into prison with the harshest sentences are often those who insisted on trial, believing that because they were innocent, they would be found innocent. In expecting justice and trusting the system, Hedges goes on to explain, they are handed sentences often decades longer than what they would have gotten with a plea deal, as a warning to anyone foolish enough not to plead guilty. This explains why 94% of states' cases end in plea deals. When considering that the state's primary focus is securing a criminal conviction, these facts are important because they highlight the contradiction of a trial's supposed function. A guilty finding is the objective, so it creates no surprise that evidence is withheld and government corruption exists. Because it is very unlikely a trial will uncover wrongdoing, the facts show that poor individuals of color, even when innocent, are discouraged from going to trial. The media either plays an instrumental role in this discouragement or aids in obtaining a guilty verdict in the event of a trial through its racialized coverage. Because these defendants of color are not on bail, they are often shown cuffed and shackled, painting pictures of black criminality that bolster the public's preconceived notions of guilt. Consider the news coverage of Karen Reed. She walks freely into the courthouse. She is not surrounded by court officers, and cameras zoom in on you with your sign supporting her. The optics are different. The narrative surrounding Karen Reed's trial is that she is a woman heroically standing up against police corruption. Unlike in a case with a poor black or brown defendant, media coverage has exacerbated the possibility of innocence, incentivizing Karen Reed to go to trial. Karen Reed's socio-political and socio-economic status intertwined with her whiteness creates an unprecedented dynamic in a courtroom. We see a trial functioning in the way it should but does not, to reveal truth. U.S. Attorney Eugene Levy of the District of Massachusetts independent investigation of the Karen Reed case was the biggest game changer in the search for truth. The police department involved in Karen Reed's case did not willingly hand over the controversial emails and texts. Had it not been for the U.S. Attorney's investigation of the case, prompted by defense counsel's alert of possible police wrongdoing, the prosecution would not have been compelled to turn over their files. Without that, the crucial pieces of evidence would not have been uncovered. The process in which the defense was able to obtain this evidence is unheard of. In fact, the last time the U.S. Attorney's Office intervened in a Massachusetts criminal case was in 1990. Charles Stewart had murdered his wife in an attempted racial hoax, causing the Boston Police Department to terrorize young men of black and brown communities. After Stewart committed suicide, black organizations such as the NAACP had to beg the U.S. Attorney to investigate the BPD. The investigation uncovered that the crime was in fact a racial hoax and that tactics used by the BPD against minorities were improper. Despite its ability to uncover truth, it's been 3 long decades without U.S. Attorney intervention. It's evident why now. I do not blame Karen Reed for the unprecedented treatment afforded to her due to her class status and white privilege. I truly don't. Though I am sorry that Ms. Reed has had to endure a likely cover-up, disrespect, and lack of professionalism on behalf of law enforcement, I am thankful for what her case has revealed to the world. Police corruption is real. Just ask them. Sean Drumgold, Sean Ellis, Sean Jenkins, Joseph Cousins, Stephon Cowens, Robert Foxworth, James Lucien, Ronald Qualls, Raymond Gaines. These are just a handful of black and brown individuals whose cases were overturned due to police misconduct within the last 3 decades. Collectively, they have served centuries in prison. For every Karen Reed, there may be dozens of them. According to Globe staff Andrew Ryan in his article on wrongful convictions and police misconduct, 2021 Suffolk County data reveals 75% of men, 26 to 34, exonerated in Suffolk County criminal cases in the last 3 decades was due to some form of misconduct on behalf of law enforcement. It is worth noting that Ryan highlighted this data only considered exonerations, not other outcomes such as vacated verdicts. For many instances, the exonerating evidence was deliberately withheld for absurd amounts of time. For Sean Ellis, it was 22 years. For James Lucian, it was 27. For Robert Foxworth, it was 30. 79 years of life gone. A U.S. attorney investigation would have uncovered all of this in year one, allowing the criminal justice system to function in a way that prioritizes truth. So why are government officials not utilizing this corruption curtailing measure to aid poor black and brown men that are disproportionately impacted by the criminal justice system? Frankly, it appears that they just do not want to or do not care to. The concept of criminal justice seems inane when criminal injustice serves as the antithesis. Every day becomes clearer that the police, the courts, the media are all racialized institutions reliant on the marginalization of black and brown individuals. Securing convictions of poor minorities must be done by any means necessary, showing that true justice and truth-seeking are not the real goals of the legal system. It is why when officers are cited in misconduct leading to the overturning of a case, there are rarely ramifications. Boston police officer Daniel Keeler had some type of negligent involvement in many of these cases highlighted above. Despite the Spotlight series in the Boston Globe and an internal investigation conducted by the BPD, Officer Keeler was never sanctioned and was able to retire with pay. Lead Detective Michael Proctor in the Karen Reed case was suspended without pay, a clear anomaly in light of the overabundance of black and brown cases where corrupt officers are running free. Something needs to give. Many of you have asked the question, who else is this happening to? The black and brown community is the answer. We need your help. Let the police know they cannot be entrusted to police themselves anymore. Demand the U.S. Attorney's Office to commit to investigating cases, past and present, going forward. Do not let them tell you they lack the manpower. Make them figure it out. Go further. Urge the U.S. Attorney's Office to have the Department of Justice investigate the racial disparities the Massachusetts Supreme Judicial Court has already admitted exist. Make them publish findings to provide redress for those wrongfully impacted. Privilege and class should not determine an individual's due process. You will not allow them to continue using the legal system as a caste system. Ask for unpaid suspension when it comes to police and prosecutorial misconduct. Push for the Massachusetts Bar Association to strip these prosecutors of their ability to practice law. Compel the Post Commission to decertify these officers. Tell them you are tired of them being able to relocate and prosecute and police elsewhere. Change will not come without accountability and oversight. You know these things are possible because you have seen many of them with Karen Reed. Will you fight for us like you fight for her? Signed, the voiceless, disenfranchised, and disposed of.